Okay, I think we are all here. Thank you everyone for attending. I'm going to call the meeting to order. And then our first order of business, where did my thing go? First order of business is the approval of the minutes on September 19th and October 10th. Connie sent that out, and I think Marcus had sent that out earlier. And so hope everyone has had an opportunity to review. Are there any edits that you would suggest or corrections? I spoke to Marcus about this earlier. I just have two very small ones. On the September 19th minutes on the first page, where I call the meeting to order and say that we're going to take the items out of order, I would just delete the last phrase, to wait for Commissioner Lewis. We took the items out of order. So I just wanted it to be clear. And then on October 10th, on the last page, there's two pages, the second page, where the motion is presented. I think the motion is pursuant to the request. So I said pursuant to the request, rather than Chair Bisigal asked to extend the time to hear the cases to the week of April 1st, 2024, and then delete the time at which the motion was approved. I just didn't think that we needed it. So those are my suggested changes. I talked to Marcus about it. Marcus, did you have any concerns about those edits?
No concerns. Those are good changes.
Okay.
So we'll make those changes.
Thank you. Does anybody have any other suggestions or corrections? Does anybody need more time? Okay. All right. Seeing none, with those corrections to the minutes, they are accepted. And thank you, Marcus.
Of course.
So the next order of business is the executive director's report. Marcus will be presenting that report.
Yes. Okay. I will share my screen. Starting now. So I think you see before you the HCRC fiscal year 2024 mediation program year to date. So I know we have a lot to cover today. I'm going to go through these fairly quickly, but if there's any questions, feel free to chime in. And it also has been quite some time since we had a report. So I think everyone wants to know where we are. So as of the last report, which was back in September, since that time, we've had some additional cases going to mediation, so 13 in all year to date. And we've also had 4 additional cases successfully settle in mediation. And so year to date, there are 5 settlements, 9 cases went through the process in all, 55.6% settlement rate. And of those mediated cases, the ones who's that successfully settled, since last time, there were 2 cases primarily based on sex, including one based on sexual harassment, one based on arrest and court record, and then one based on retaliation. And so there's a mix of employment and housing cases among those. And going further down, so
that is appropriate in the past, except for during COVID.
right. I can hear someone's
take that
background,
up,
I think.
anybody would like to discuss that?
Oops. Okay, so the cases were settled, 2 of them through the Mediation Center of the Pacific, 1 through a private mediator, and then 1 additional since last time with our internal process at the HCRC. So that's overall, again, 5 settlements out of 9 cases going through the mediation process. Okay. Anyone have anything would like to ask about or comment on that? Okay, I'm going to move on then to the caseload report. I think that worked. Do you see that now? Okay, great. So I don't expect anyone to know what numbers were last time, but if you take a look at the changes from last report, that gives you a summary. So we have in total 349 open cases in our caseload. That's 3 additional from our last report in September. But since that time, you can see here that we have had closures and dispositions in cases all through our caseload. So, 2 fewer cases from 2018, 8 fewer from 2019, 7 fewer from 2020, etc. And so it's been sort of steady progress, I would say. The percentages of the caseload, we are reducing the oldest numbers of cases in our caseload. If you go down further about the case aging, which is sort of a moving target kind of a thing, pretty similar to the previous report. Still higher than we'd like to see in the oldest category, which is 2 years or older. But we are continuing to work on that. And then going down to the breakdown by type of case, I did notice we had a bit more housing cases in our caseload than we normally do. Other than that, everything looks about the same. And I did note that in the housing side, we are really processing cases and getting them into our system. Let's see. And I'm going to go further down the page here where I was able to add in a column on the far right, which represents all the statistics from the past fiscal year, which were included in our most recent annual report. And so I think maybe take some time to look at it outside this meeting. And if anyone has any questions, we can come back, revisit next time. The one thing that I saw, which is a bit of a, well, there are 2 things. If you take a look at the complaints filed, last year was quite an anomaly with the numbers of complaints filed because we had 510, and that's much higher than any other year. And that's because we had a large influx of cases from our federal partners dealing with, I think, COVID-related issues, particularly on the employment side. And so that's where we had a large influx, and you're not going to see that again. You don't see that throughout our 10-year history here. So that was one thing I noted. And then the other is we were lower in terms of our investigations closed. Not sure exactly the reason for that, but it was pretty noticeable and perhaps something that we need to focus more on. But in any event, again, don't want to spend too much time going over this report in this meeting. And if there are questions, we could certainly fill them now or wait till next time. Okay. And then the last section I have here would be the year-to-date statistics. And here, as I've been reporting in the past, it looks like the numbers of pre-complaint questionnaires received is getting to pre-COVID numbers. And so that's good. And we're keeping up with the intakes on those cases, complaints filed. And then currently the year-to-date investigations closed is maybe more in line with what you'd want to see based on past years. So that's the report I have for you. Anyone have anything to ask or add to this? No.
Thank you, Marcus. I did have a question just in terms of the cases closed.
Sure.
Let's look at the numbers the next time and then see how it is, because I do know that you were short-staffed for a significant amount of time as well. So
Right.
I wonder if that has an impact on your ability to close those cases.
Yeah, I mean, certainly, I would assume. And so, yeah, we can look at our numbers for next time. I will note, I mean, this is a bit out of order, but since the last time we met, we have added one additional investigator. And so it's a long awaited recruitment process that we went through. And so she started earlier in the month. So she's really new, but happy to have her. Okay. So
That's
I will
great.
stop sharing here. Yeah.
That's great. And staff shortages are not uncommon in this job market. So that is something I understand that is a challenge for the commission, the agency as well. So thank you for working on that. It's not easy. Okay, thank you, Marcus. Let's go on to the chief counsel's report, Connie.
Okay. So I am actually very pleased to report that Morning Hill Foods versus the Civil Rights Commission, 6 years later, it went to the ICA, or it was appealed in 2018, and the ICA just issued a summary disposition affirming the circuit court's order. So
Oh.
this was a case, an age discrimination case, and so with that, they can try to do a cert petition to the Supreme Court, but most likely it's probably finished. Um, and then on other good news for number 4 in the agenda, or B under the chief counsel's report, the docketed cases, parties have just notified adjudication section that they have agreed on the terms of settlement. So they will be filing motions to dismiss the case based on the execution of the settlement. So that's great news for us. And we've already notified the AG assigned to the commission, so they're aware of this case status update. All right, so on the proposed rule amendments, I would like to ask the commissioners, if there's a date, I think we should set a date for the public hearing on the rule amendments. We do have to give 30 days notice by law. So we're probably looking at sometime in March, and we would like to do it, after the ledge session dies down. So if anyone can make a date in mid-March, that might be a good time to have it if it works with everybody's schedule.
So Connie, what you're asking is that we all be present for the hearing?
From what I understand, just a representative has to be present. I think, Leanne, you mentioned before that you would be willing to be the representative. Do you still want to attend the public hearing, or anyone else who's interested?
I am
Okay.
happy to have any of my other fellow commissioners
Okay.
be the representative if they are so inclined. But if they are not, I am more than happy to take on that responsibility. So
Okay.
if
I nominate Leanne.
Okay.
It's going to be fun either way.
Is
Okay.
there only one representative? on the commission?
Well, what would happen is the commission's representative would report back to the commissioners, at a meeting where there's quorum. So no action would be taken if all the commissioners aren't present at the public hearing.
and there's no prohibition on having other commissioners there.
Right.
Well, I'll be happy to attend with Leanne, but I don't particularly want to attend as the representative. I think the commission, our chair should be the representative if possible.
Okay, we can coordinate schedules.
Okay.
Yeah, and I mean, depending on the schedule, I mean, I'm open and subject to scheduling issues, but I'm also
Right.
open.
Okay, that's fantastic. So maybe Connie, maybe we'll firm up William and myself, and then if anybody else can attend, then they should feel free to attend.
Okay. All right. Sounds good.
Good work.
Okay, so moving on to legislation, okay. All right. So I'm going to share my screen. Let's see. Okay. All right, so I did prepare a packet with some of the bills that came in, and we kind of had a slow start. So this isn't an extensive list, so hopefully we can get through it all. But we did get a lot of bills last minute, so hopefully we can, discuss everything on our list today. I did attempt to, organize the bills by subject matter, employment, housing, and then just general civil rights issues or issues that might impact us. The DLIR does assign certain bills that we might have to deal with. So I did want to just, make the commission aware of those bills. We might just be monitoring them or not commenting or supporting or opposing. But this list also includes those. So we could just go down the list, I guess, and then have discussion about it. And this was really a team effort. So during the discussion of the bills, staff is free to jump in with any comments about it. So House Bill 1791 relating to employment, it requires employers with 5 or more employees in the state to offer reproductive loss leave for employees. It also covers partners of individuals who miscarry, and it has a lot of definitions on miscarriage, reproductive loss, stillbirth, and it also includes failed surrogacy and failed adoption. So after staff, discuss this bill, we would recommend support. And I think this is actually a really great bill because it does expand protections. So even though it doesn't fall under the HCRC jurisdiction, not something that we would enforce, it does impact the groups of people that we commonly see with pregnancy-related disabilities or pregnancy-related medical conditions. And so this is just an expansion of that right. So staff would recommend that that the commission vote to support this bill to protect employees and those experiencing reproductive loss.
Okay, can I have a motion?
So to support House Bill 1791.
Thank you, William. Do I have a second?
A second.
Any discussion? Okay. Hearing none. Any objection to the motion to support HB 1791? And if you do, you'd have to speak up because the screen, I can only see a few folks. Are there any objections to supporting? Okay, hearing none, the motion passes.
Okay, so Senate Bill 2100 is an interesting bill. It's related to credit history and credit score. It has 2 parts. It impacts housing and also employment. So I did place it in 2 places. So this is a duplicate, but we can discuss it all right here. So it amends HRS 368F, which is the source of income section that passed last legislative session. And then it also repeals in whole HRS 378-2.7, which is within the HCRC jurisdiction. And this is where staff can jump in because I know Marcus and Joey had done a lot of research on other states that had passed similar laws or had similar laws in place and what that limitation is. So the interesting thing for HRS 378-2.7, which is within the employment discrimination laws, is it creates some exceptions to the law. So an individual can't be discriminated based on their credit history and employment, barred from employment, discharge, etc., except in certain circumstances or for certain bona fide occupational qualifications and certain conflicts, right? So if it's a financial institution where they might have to consider a federal law, that is what 378-2.7 carves out. So it includes managerial positions, it includes supervisors, which is a little bit broad, at least in our staff's opinion. So it's an interesting bill. On the housing side, it is really interesting too, because the source of income isn't within the HCRC jurisdiction. If they wanted us to have, enforcement, it would be placed in 515, but it's right next to the source of income section. And it's it's really interesting timing as well. So for at least on the employment side, this was in response to the Great Recession of 2008, 2009. The law was passed in 2009. And I think this would impact a lot of individuals at the moment because, I mean, with the Maui wildfires, there are a lot of individuals who became homeless and jobless, and it could have impacted their credit score, the credit history. So I think that could be one of the intentions in bringing this this bill. So we did, and Marcus might have a little bit more comments on this. So we would support the intent, but we do have reservations and comments, especially on repealing the employment section, because it does have limitations. And from what we had looked at in other states, those states that had passed non-discrimination laws based on credit history and credit report, there were limitations. And, those limitations were similar to, or if not exactly the same to how our law is currently with financial institutions. And I'm not actually sure. Marcus, did you see any other with manager and supervisory positions in your
Yeah,
research?
I can chime in a little
Okay.
bit. So I did some research and I hope it was complete, but what I saw was there were 10 states that have credit history discrimination prohibition in their laws related to employment. So making sure we separate these out. So not housing, we're talking about employment at this time. All of those 10 states had some exceptions to just no credit history inquiry at all. And so most of them had to do with persons who work for financial institutions. And I think that's pretty understandable. There were also exceptions for positions which by law, so for example, by federal law, a credit history check was required. And also there was an exceptions for positions for which a credit history inquiry would be a bona fide occupational qualification. And so I think it's pretty important to preserve those exceptions within our law. And if we were to delete all of them as the bill suggests or the bill proposes, I think we'd be hanging out by ourselves. And I think it would be very much opposed by the business community is one thing. But the one part of the exception that we have already would be and also is proposed to be deleted has to do with managers and supervisory employees as a broad category, right? And so I saw in my research that other states, a few of them did have an exception for managerial and supervisory employees, but most of them also tied the credit history inquiry to the position itself. So there had to be some sort of substantial, what word did I use? Like a connection to the job. It wasn't just any manager in any sort of industry. So I think that's where we have some comment that we support parts of this bill, but some I think we need to modify or keep out.
Right. So staff would recommend that we'll support the intent, but we oppose as written, and we can work on alternative language, maybe limiting, repealing of just, managers and supervisors that doesn't have a substantial relationship to their job duties, something like that. But as written, we would probably oppose.
Well, I'll be happy to move.
I'm
Yeah,
sorry,
because
can I ask a question first? Sorry, before
Yeah.
you make a motion.
Well,
So-
because the rest of it is debate, so usually you make the motion and then debate. But
I was just gonna ask what the position is on the
Housing.
housing side. Yes, thank you.
That's a great question too, because we definitely understand why, you know, some landlords would require a credit check or some type of credit history. And the way this bill is written, it's pretty broad. So it's pretty much anything involving credit. So not just your credit score, which, you know, can be manipulated, but also credit history and things like that, which might impact how likely a tenant is to pay, you know, on time and be able to just pay in general. So it's pretty broad. The way we have it written in employment currently is credit history and I think credit score. So it's a little bit more limited how we have it in employment now as a protected basis, but this bill is much broader, and it doesn't really define credit worthiness, but it might be, you know, obvious on its face what that means, but it's pretty
Right.
broad.
For the purpose of moving this to discussion, could we
Mhm.
say the staff position is support intent?
Oppose, that's right, yeah, but suppose.
Well, okay, I guess we look at the whole bill, right? So how are we gonna phrase this?
So in the past, we would say that we support the intent of the bill with the following reservations, and then a colon, and then we used whatever language you had discussed.
Got it, okay.
Yeah, I would say that was appropriate. The concern I have about this bill is that it has no preamble whatsoever. It's introduced by one senator, and there isn't a companion bill.
Mhm.
It has no preamble, so it has no basis upon explanation on why this is important. We can assume why it's important, and I think that's a valid assumption that there are folks that are negatively impacted by COVID related employment issues, and you know they're trying to find housing, and it may impact folks, you know, who are employed as well. But that is not clear from this bill, and so I would agree with staff that we can support the intent to the extent that it is aimed at you know, remedying, you know, these types of discriminatory practices. But I don't think that the bill, you know, based on what Connie says, I think credit worthiness is not clear. And I think that the downside to this bill, you know, may be greater than what it's actually trying to remedy. But I do like the fact that we would, you know, be cognizant of folks that are not able to get housing, advance, or get higher pay in employment because of, you know, unfortunate circumstances that may be beyond their own control. So I would entertain, I think, does that change your motion, William?
Oh,
Okay.
so the understanding would be that after the colon, that we support the intent with the following reservations, that you would, staff and would be able to summarize the reservations expressed here.
Okay. Thank you. And so I would ask for a second.
Second.
Thank you. And then is there any further discussion before we vote? Okay. Okay. So we're gonna vote on whether or not, well, whether you support the staff's position of providing support of the intent of SB 2100 with clarifying exceptions. Are there any objections? Okay, hearing none, the motion passes. Thank you.
Okay. Moving on to Senate Bill 2930 relating to employee benefits. So this extends under certain circumstances the family leave period for up to 8 additional weeks for employees who are unable to perform their employment duties due to birth of a child who is required to stay in a neonatal intensive care unit. It also requires the Civil Rights Commission to amend its rules regarding pregnancy to include neonatal care as a medical condition due to pregnancy, childbirth, or related medical conditions. But it doesn't amend, it's not placed in 378 part 1. So it amends 398 because it relates to, I think, state workers, right? So our staff recommendation would be to support and offer comments on the remedies, because as written, it sounds like they're trying to include it under our jurisdiction to include neonatal care. And this is a great bill. So it discusses kangaroo care, where individual might need leave from work because they need, that skin to skin contact. It could relate to not just the person giving birth, but also the partner. So it's a good bill, but it is, in our opinion, slightly misplaced in our rules, because it would be a substantial change to the pregnancy rules. So we feel like there might not be a need to amend our rules for this bill.
Okay, so Connie, you're saying that you support the fact that there's an expansion of these pregnancy protections, but you do not believe that the Civil Rights Commission rules need to be amended in order to affect these protections?
That's correct, yeah.
Okay, so can I get a motion on the staff's recommendation that we support this bill with comments, right?
So moved.
Do I have a second?
Second.
Okay, thank you. Any discussion, any questions, any further?
Okay, just out of curiosity, are we supporting the bill as written? Are we supporting the intent of the bill?
As written, it's a good bill. The only issue that we do have is the Civil Rights Commission's requirement to amend the rules to include the neonatal care. So we would support the intent of the bill to expand pregnancy protections.
So our motion is to support the intent with comments, clarification, whatever we want to use.
Oh, okay. Okay, so that's an amendment because you made the motion, Joan. You can amend. I think I'm learning from William. You can amend your motion.
Okay, William,
Yes. You can
do I need
amend
to do something other than make sure I'm clear on what I understood when I said I was going to move it?
Sure. I mean, whether or not we're supporting the bill with the following reservations, or supporting just the intent of the bill, should be in the motion. I get the feeling that staff was recommending we support the bill with the following,
Okay, then let me ask staff, is that what you intended? That we
think-
support the bill as written, just with reservations or comments as it relates to putting it with us?
That would be where reservations lie, because it would require us to change our rules, amend them as written. I mean, we had also discussed during this bill, discussing this bill, that we could also offer alternative language, on what other remedies might be available. But because nothing in this bill points to what the remedies could be, for individuals who might be aggrieved, except that they would place or require us to amend our rules.
Okay, then I would like to amend my motion to say the intent, that we support the intent of the bill with reservations. And then we spell out those reservations, because I think that's more appropriate.
Okay. William, do you still second this motion?
Yes.
Okay. Any other further discussion?
I would like to ask, is the bill define as it's written now, what is neonatal? Because I'm sorry, that's not a term with which I'm familiar.
I believe it
Yeah.
does.
It actually
Yeah.
it's a little more specific than just neonatal care in general, because what the person who needs the needs this bill to expand their leave protection, it's someone who has a child who um is born prematurely, has to be in a neonatal care unit, and then after they're discharged, they can have additional time to care for the child. So it actually talks about the person either having to express milk for this child or kangaroo care, which is defined within the bill, which is the skin to skin, chest to chest kind of contact. So it's a little, I think it's actually saying neonatal care is a bit limiting. It's or not, it's that's too broad. It's actually a more limiting type of conduct that's at issue here.
So the bill doesn't use the term neonatal, it uses these other terms.
Well, it kind of conflates it, because where they talk about neonatal care is to amend our administrative rules to add neonatal care under the pregnancy, the disability related pregnancy conditions. And that we think is not appropriate and is actually a bit different than what's described in the main part of the bill.
Because that would, as far as I would understand, if it's going to be in the language of the bill, it should be defined. And particularly if they're asking HCRC to amend our definitions and regulations in order to include neonatal, then there needs to be a clearer definition of neonatal that should be in the bill. So that'd be, for me, a shortcoming that should be addressed if it's beyond our supporting the intent.
I think that's a good point. Yeah.
Makes sense. Okay, any other comments or questions? Okay, seeing and hearing none, any objections to our support of the intent of the bill with comments and or reservations? Hearing none, the motion passes. Thank you. And so we'll go on to the next bill, Connie.
All right. So House Bill 1713 relating to family leave and SB 2225, they're not listed as companion bills, but they have the same language. I couldn't see anything that was different between the two, but I don't know if I looked close enough. But it establishes a paid leave program for state and county employees, and it authorizes a qualifying employee to take up to 12 weeks of paid leave for birth or placement of a child, or to care for a family member who has a serious health condition. So it's not just for birth or adoption purposes, but it's also considers care for elderly parents. In the preamble, they do mention that Hawaii has one of the largest populations of aging individuals, and people have to care for them. It impacts women and minority groups. So it's a really great bill, and pretty detailed. So staff recommendation would be to support. I'm not, I might have put support intent, but I think it was just to support, not with any reservations.
Okay, so can I have a motion to support? This would be both for HB 1730 and SB 2225 because they are the same bill for all intents and purposes. Is that correct?
To support House Bill 1713 and Senate Bill 2225.
Great, thank you. Do I have a second?
Second.
Thanks, John. Are there any comments, questions, discussion? Okay, hearing none, I think we're ready to vote. Are there any objections to our support of these two, the House bill and the Senate bill related to family leave? Okay, hearing none and seeing none, the motion passes. Thanks, Connie.
All right, so moving on, so we already discussed Senate Bill 2100 relating to discriminatory practices, so we don't have to go over that again. But Senate Bill 2073 is it allows the counties, individual counties, to prohibit discrimination against renters based on their source of income. So this bill was also a similar bill was introduced last legislative session, and we supported that. And this would allow the counties to be more expansive in protecting individuals seeking housing than what the state statute currently allows. And actually, this reminds me, so in the past, when we've had similar bills with that have come before the commission that commission has already, discussed about, we would like to ask the commission to vote that we can submit substantial similar testimonies and take similar positions if we're not able to cover everything in this, in these meetings. And then if we do offer testimony on the similar bills, then we would report back to the commission, and our position can be discussed as well. And the commission can then review those bills. So if that's at all possible, I think that would be really helpful, because we did get a lot of bills come in at the last minute. So I think next week is probably going to be pretty lengthy for our meeting.
Okay, so Connie, we have done that before.
Mhm.
That's a separate motion.
Okay.
Do you want us to take that now, or do you want us to take it at the end of this discussion?
We can wait until the end, so it's not confusing.
So Marcus doesn't have to write that in the middle.
Right.
Clear. Okay.
Okay.
Do you have any other comments on this bill, housing discrimination?
No, other than we had supported this in the past. It's a good bill, expands protections.
Okay.
Yeah.
Okay. So
So, my confusion is that I thought that this was already a discriminatory practice, and that credit history was already protected class. So is there, maybe I'm just not remembering.
Yeah.
So
So-
that one of the things would not be necessary, and
Sorry?
it's already covered.
So source of income was passed last year, but there were a lot of exceptions, I think, like on the size of housing providers and things like that. So this would allow counties, if they want to be more expansive, if they want to target, smaller housing providers, they would be able to create laws to protect, individuals seeking housing from, a landlord with 2 units, or less. So it just allows them to take more action to protect, the citizens of their counties, or people of their counties.
you know what, Connie, I take back what I just said about keeping it to the end, because what you're saying is this is a similar bill. So let's just vote on that.
Okay.
That kind of presumption that the commission will support bills that are similar to the position we took, or the commission will take consistent positions if the bill is substantially similar to one we've taken in the past, or to one that we've taken a position on in the past. And that would include SB 2073 relating to housing discrimination. Can I get a motion on that?
So moved.
Thank you. Can I get a second?
Second.
Thank you, William. Any discussion or questions on that proposal or motion?
The only thing that I would wonder is, do we have community clarity on what substantially similar is? Do we feel confident that we have enough of that amongst all of us?
I would say that substantially similar would be pretty much word for word, bill that was introduced last session to this session. If anything was materially changed, I wouldn't consider it substantially similar. I'm not sure if other would have a
Yeah.
different opinion.
And I think out of caution, if we feel it's questionable, we
Mhm.
would not testify. We just wait until we can meet again.
And I appreciate that because I could see if it was the intent, because this intent is right in line with what we agreed to last year. Even more so. And I can imagine, particularly as it relates to Maui County, something like this would be even more important. Like something like both of the bills that we're saying we support would be important, because to your point about, we don't know about credit histories right now. We don't know about sources of income right now. But I think it's going to matter that landlords aren't able to discriminate. So I guess my feeling is if the intent of the bill if the intent matches what we have supported in the past, and there's no specific items that would be different, I could live with that.
Right. So Joan, what you're saying is we just don't want to expand or broaden what we have agreed to in the past.
Right. And I think that what we're talking about with this, I think this particular bill is a great example of something that actually moves forward on what we believe, but it doesn't add anything that we didn't already agree to.
Okay.
So,
William.
and I'm glad I moved it. So there.
Thank you.
So, I really believe, or at least unless my memory has completely failed me, that we passed a similar motion to this, last year.
Good.
And we've spent some time hammering out language, which seems to me should be good and generic enough to use this year, that it would allow this kind of situation to be addressed, where a bill comes in after we voted on one that's almost the same content. But I can't remember all the language. I know we relied well, again, my memory is not that crisp on this, but it seemed to me that we would rely upon staff for that decision.
Yes.
So I think it would be helpful if we go back and look at that, the language we used last time, for consistency's sake. Just that use it
Yeah.
again.
I think that's a good idea, William. But in terms of our understanding, all the commissioners, I think we have a clear understanding that we would support something that we have supported
Right.
in the past.
Sure.
But Marcus, if you can go back and pull that language from last year's minutes, that would be helpful for us.
Okay.
Yeah, we're gonna meet next time anyway, so.
Okay. So are you comfortable voting, William?
Because if necessary, we can amend it. It's a single, because the way the agenda is, it's a single session, so we can bring it up.
Yeah,
again.
we can do it next time. Yeah. Okay. So the motion's on the table. Any further discussion? Hearing none. Any objections to the motion? Hearing and seeing none, the motion passes. Okay, Connie.
Okay, so this bill actually was also a bill that was introduced last session, didn't pass. It's Allie's Law. It adds a new part to HRS 321, and it requires a retail establishment with an employee toilet facility to allow a customer serving from an eligible medical condition to use that restroom during normal business hours under certain conditions. And so this is a really good law. We supported it last session, and I think nearly 20 states have already passed versions of this bill. So we would be, in line with what it looks like the trend is going, and it would increase accessibility for individuals with medical conditions to, partake in public accommodations, things like that.
Any reason that we need to vote on this matter since it is the same as the one we supported last year?
I don't think so. Yeah, it looks pretty much the same. Yeah.
Okay. Is everyone comfortable with that? Okay. If you're not, you can just let me know. Everybody's face is really small and
Well, I have no problem with, the motion being made and adopted again,
Okay.
I mean,
Okay.
so.
I'll take a
it's
motion.
just a new number, right? So,
Sure.
so I'd be happy to move that HCRC support Senate Bill 2059.
Okay, do I have a second? John is seconding. Any further discussion? Seeing and hearing none. Any objections to supporting staff recommendation on SB 2059? Seeing and hearing none, the motion passes. Thank you.
Okay, so Senate Bill 2503, this is actually another one that was introduced last session. It went through a couple of drafts, and so this version of the bill, I think, was the last draft that didn't pass, but staff recommendation should just say support, not support intent with comments. So it requires places of public accommodation to provide universal changing accommodations that are equally accessible regardless of gender. And this version of the bill explicitly excludes it from HCRC enforcement. And I think that was the biggest issue that we had last year on this, because it included it in HRS 489. And so I think by adding it to this bill, they're trying to address that issue that we had with it. And it's a really great bill.
Okay, terrific. I'll entertain a motion.
I move to HCRC, I should say that HCRC support, it's a Senate Bill 2059, do I have the number?
2503?
Oh, 2503, sorry, yes, that's right, we just did the, yes, I got all lost, but yes, so that's my motion to HCRC support Senate Bill 2503.
Do I have a second?
I can second.
Thanks, Arsima. Any more discussion on this bill? Seeing and hearing none, are there any objections to the motion to support? Seeing and hearing none, the motion passes. Connie, I would just ask that because this, I think this document is this document something you have to post publicly?
Yeah, so it falls under a board packet or, commission packet. So we do have to provide it to members of the public, 48 hours in advance of any meeting upon request. So this did go out to a few interested individuals. So it doesn't have any internal, deliberations really.
Okay. I was just wondering if there was a way to, just for your records then, to just correct what your position is that you actually have, rather than us relying on this document.
Okay.
Or either that or it's in the minutes, but it's clear what staff recommendation is.
Okay, and we'll clarify that when we do the minutes. We'll have what the staff recommendation is and corrected, and then we'll have what the commission's position ended up being. So.
Perfect, thank you. All right, algorithmic discrimination, Connie.
All right, so House Bill 1607 is an interesting one. It prohibits users of algorithmic decision-making, which is basically probably just AI programs, from utilizing eligibility discriminations in a discriminatory manner. So it requires users of algorithmic decision-making to send corresponding notices to individuals whose personal information is used. It requires notice of that they're using AI in making this determination. It requires that they have to tell what personal information is being collected, sources used to collect, things like that. So it's a really interesting bill. And I mean, everyone's probably seen news articles about the training of AI and how it could possibly, end up discriminatory based on whoever is doing the training. So I think this is a bill that's probably going to be more and more looked at. It's pretty thorough, but it also has a lot of technological, things that staff doesn't feel that we have enough background or knowledge on to really comment. So, and I did want to bring this to the commission because I know the AG requested our commission to have if we have any comments, to let them know, because it's going to be given to the AG's office to, enforce this, or also get, I think people who or organizations who use AI have to submit annual reports to the Department of Attorney General. So it increases a lot of their work that they would have to do. And generally speaking, and if I can recall correctly, I think in the past, if there are other departments that are tasked with, certain enforcement or certain duties, we usually defer to that department. We don't really, take a position of support. But they are tracking this. So I did want to bring it to the commission because it does discuss, the use of AI possibly to prevent, discriminatory eligibility instances of discriminatory manner. So so it's open to discussion. Staff would recommend that we just monitor. And if if it goes through more hearings, then maybe we can address the issue again at a different meeting, but we would recommend just monitor this bill.
I just have a comment. So I think this bill is a really good bill. I think it's a very forward-thinking bill. There are a lot of issues with using AI and these kinds of algorithmic determinations. Like you can feed in, if it's a learning AI, like ChatGPT, but it not, like a closed one. You can feed it, like if you're doing like employment searches, right? You can feed it all of the resumes that you had used in the past that were successful employees. And so you think that it's going to give you a good result because of that. But implicit in all of that data are underlying biases. And so they found that it can exacerbate existing biases. And so that's why the back end and looking at it and the AG's work in terms of the reporting is also going to be really important. I do not mind just monitoring it, but I do think it is something that commissioners that continue on in this commission and staff, that this is an important aspect of how we interact, and where discrimination can really be very insidious and detrimental.
Would it be within our purview to do what we did in other cases and say that we support the intent, and that with reservations that should be addressed by research and the Attorney General, because I think just saying monitor it, I'd prefer. I strongly believe this is a good idea to limit or restrict, if not fully ban or prohibit this kind of discrimination. Some may recall last year I brought to the attention of the commission a documentary on Netflix that dealt exactly with this, and walked the people who watched it through all the different problems that Leanne has explained very well. So I personally like to see a stronger expression of support, even if it's only supporting the intent.
One thing I would add to the discussion is I agree with everything that's been said here. I would say that even in the absence of having a bill such as this pass, if someone were to come with us with a claim of discrimination based on how some algorithm was used, and it's on the basis of their race, their sex, etc., that's a complaint that we'd have jurisdiction over, and we'd investigate, and we could find there's a violation. So I know we're not talking about just discrimination instances. I know we're talking about here sort of looking at the usage of AI as a whole. But just want to throw that in there that we haven't seen those cases, but if they were to come before us, we would have jurisdiction and we would take them.
Yeah, I
Well,
think that's a really
again,
good
I'm
point.
sorry.
Go ahead, William.
I was gonna say, I would think that rather than having the statute amended, there might be, this is another area that the regulation could say that this would constitute evidence of this algorithmic discrimination. You know, something like that might be better placed in regulation than in statutory language.
Perhaps. I do think that the notice like the notice of this and the importance of it is really important. And that's why being in law, then a lot more employers would know about it, and they would know that it's not, that they have to be careful in the use of it. Because sometimes when when you're doing an HR search, you don't know the processes that people are using, and so you wouldn't even know to make a complaint to the HCRC. So but I, Connie or Marcus, if there's no issue with us supporting the intent, let us know. But if you feel strongly otherwise.
Thanks for, I really just reading the language, I really couldn't get a handle on it. So thanks for breaking that down, Leanne. I do have my suspicions about AI and the uses and misuses of it. And so I too would support the idea of as kind of a proactive means to address what could be.
Okay. Do I have a motion?
Well, I'd like to move that we support the intent of this, of House Bill 1607.
Do I have a second? Okay, thanks, John. Do I have any other discussion? Okay. Yeah, I would just make a comment in terms of the testimony that we include, not in like maybe like 2 sentences, not a whole lot, but just like why this can be bad. So like if somebody in the public or anybody reads it, this doesn't have a preamble either. So if anybody reads it, they know why we are concerned. I think that should be clear. Okay, so the motion's on the table. It's been seconded. I don't see anybody who wants to have any more discussion, but I'm open to it if you do. Okay, and then we'll take a vote. Is there anyone opposed to our supporting the intent of HB 1607? Hearing and seeing none, the motion passes. Thanks, Connie.
Okay. So moving on to access to state funded services. So I know when I created this packet, I didn't see any, but there actually is one that I included. I just didn't put in the right spot. So it's Senate Bill 2916, which is on the 4th page, 2916, relating to health. So this is a kind of interesting bill. It requires the Department of Human Services to amend its rules, policies, and plan amendments necessary to ensure that medically necessary services, for people with certain medical conditions, including autism spectrum disorder, are covered under the state's medical program. And so it seems more like an appropriation bill, because where the HCRC is mentioned is accessibility under 368-1.5. So section 4 is just, there is appropriated out of the general revenues of the state of Hawaii the sum of blank, or so much thereof as may be necessary for fiscal year, to the Hawaii Civil Rights Commission to enforce the anti-disability discrimination laws pursuant to section 368-1.5 in accordance with this act. 368-1.5 is access to state and state funded services, and the only protected basis is disability. Individuals can't be discriminated against on their access to state services based on a disability. But this is the only place in the bill where the Civil Rights Commission is mentioned. It would require, you know, the Department of Human Services to amend its rules. And like I mentioned before, you know, generally speaking, we would defer to DHS because they are a department that would be required to take action. This just allows for appropriation of revenue for, you know, to us. So I believe I mean, we would support more funding to the HCRC. So I think staff would recommend support, offer comments. I don't know, Marcus, do you have any additional comments on this bill?
Well, I think bottom line is we would support with comments, and I mean, there's no dollar amount here. There's no expectation laid out. So I don't know what's the thought here other than perhaps that amending the DHS rule would allow there to be more complaints or more people falling within the category of people who could file complaints with us. And so I don't know what kind of research or thinking has gone into what that amount might be, and I don't think we have any idea what that would be either. But putting that all aside, I mean, I do think we support it, yeah, with comments.
Okay. I'll be happy to move to support Senate Bill 2916 with comments.
Okay. Second, I do have a second.
Second.
Thanks, Joan. Any other discussion? Okay, hearing or seeing none. Any objection to our support of SB 2916? Okay, hearing or seeing none. John, we just voted on 2916 to support. I just want to make sure that. And if you have any objection to that, then let me know. Okay, hearing or seeing none, the motion passes. I just wanted to note that I think our SEMA dropped off. Is that true?
I see her.
Nope.
There you are. There you are. Okay, you just got out of order, so now I can't see with everybody. Okay, thank you. All right, go ahead, Connie.
Okay. So these bills I didn't categorize as, you know, employment, housing, or anything like that, but they do impact the commission or relate to civil rights in general. So Senate Bill 2105 relating to higher education, it authorizes students or individuals from a co-fund nation, refugees, or special immigrant visa holders to qualify for the resident tuition fee within the UH system under certain circumstances. And staff would recommend supporting this. You know, the current law, I think, allows COFA individuals to qualify for 1.5 the tuition for a resident. So this would kind of equalize it unless it doesn't kind of other them in a way because they are allowed to travel freely, and under how the current law is worded, you know, to be a resident, you have to be in Hawaii for 12 months without leaving. So this would support COFA immigrants and other individuals who have special immigrant visas to qualify for tuition and increase, you know, access to higher education. So we would support this.
Okay. So the staff is recommending support of SB 2105. I will take a motion.
I'll move.
Thank you, Arsima. Do I have a second?
A second.
Thank you, John. Any further comments or discussion? Seeing or hearing none, are there any objections? Seeing or hearing none, the motion passes.
Okay, so Senate Bill 2433. This requires UH to provide menstrual products free of charge to all students on campuses. And staff recommendation would be to support individuals who menstruate or unable to access, or unable to access menstrual products face a significant barrier to education that others that do not menstruate do not. So this can impact an individual's ability to learn or limit the full educational participation. So staff would recommend supporting this.
Thank you. Do I have a motion?
Yeah, I'll move.
Thank you.
Second.
Thank you. Any other discussion? I don't see or hear any. Anyone opposed to supporting SB 2433? Hearing and seeing no objection, the motion passes.
Okay, moving on to House Bill 1740 relating to sex-specific student athletics team. This creates the requirement that the Department of Education designate sex-specific teams for the purposes of gender equality in school sports. Staff would recommend opposing this bill because it targets transgender individuals and greatly and inappropriately puts the burden on the DOE to create rules to resolve disputes under this section, which yeah. So we can have further discussion, but we would just generally oppose this bill.
Okay, thank you, Connie. Do I have a motion?
I move that we oppose.
Okay.
Second.
Second, beautiful. So William moved and Joan seconded. Any discussion on this bill? Okay, hearing or seeing none, we will vote. Are there any opposed to opposition of SB 29? Oh, I'm sorry. Yeah, SB 2916. No, that's not it.
It's
Sorry,
1740.
1740, HB 1740. Okay, seeing or hearing none, the motion passes that we oppose HB 1740.
Okay, moving on. We already discussed SB 2916. So SB 2037 relating to state holidays. This actually is the topic for the next several bills. So there's, a Senate concurrent resolution on the Lunar New Year, or, state holidays, Lunar New Year. I included it because I thought the commission might be interested in following it, or if they have any, opinions or discussion that we might want to have. These were assigned to us by the DLIR. So I did want to bring it before the commission to encourage discussion. And it encourages recognition of minority groups or groups who do celebrate the Lunar New Year, which I think is always a good thing.
Do you have a recommendation, Connie?
I would recommend just monitoring it.
Okay.
I mean, I generally support it, but I'm not sure what we decided on. I think we actually didn't get to this point in our staff discussions. So.
But your recommendation is that we monitor.
Yeah.
Okay.
So can I ask if we're not going to support in any way or oppose, but only monitor, is a motion necessary? Because you'd probably just be doing that anyway.
Not
Because
necessary.
if you have a motion to monitor and it doesn't pass, it presumes that we're not going to look at it or monitor it or think about it. I don't know. I was just thinking that perhaps that's it's not necessary to have a motion to monitor.
I don't think we've ever had a motion to monitor, so I think it's just they'll just keep it on the list. So we'll see how it moves through.
And if something comes up, then we can bring it in front of the commission again if we decide we do want to comment or, support or oppose. We would definitely revisit this issue, I think, or this bill.
Okay, great.
Okay.
Moving on to the Sunshine Law.
Okay, so let's see. Relating to open meetings, House Bill 1600. It requires that a board may schedule a meeting for discussion and decision-making on a report by an investigative group 6 days before the investigative group had made a report of its finding to the board. So I believe in the past, and because I am new, anyone please correct me if I'm wrong, for issues relating to open meetings, sunshine law, or UPA or things like that, we generally defer to OIP, Office of Information Practices, because they have expertise on this issue. You know, they're the ones that people go to resolve complaints. And that would be my recommendation here as well. And also monitor it. And if anything does come up, then we can address it if it does move forward at the ledge.
Sure.
Hang on.
Go ahead. Go ahead. Did I hear somebody? No. Okay. I think that's what we've done in the past. So, you know, I'm okay with that. Is there anybody else that would like to take a position on any of these bills? Okay. So Connie, if you can just monitor, and if there's anything that egregious comes up, we often defer to you folks because it's actually burdensome. It can be burdensome on you.
And I know in the past we have done staff testimonies, but I couldn't find anything in the last couple of years. But I think, yeah, you're right. It does impact our agency as well.
Yeah, so we don't mind taking a position, but we won't. We'll just rely on you to make sure that it's monitored and then see. And we often, if we did, I think we talk to the agency. And I don't recall if we ever did submit testimony though, because we do not want to oppose any open meeting requirements. It's
Right.
very important.
More accessibility is better. More sunshine is better. Definitely.
Okay, so let's move on.
Okay, so that covers HB 1600, HB 1599, HB 1598, I believe. HB 1597, SB 2116.
Yep.
You know what? I mean, we could discuss this one. I think there was a similar bill, and I haven't had time to look at our past testimony, but it requires the use of interactive conference technology to remotely conduct public hearings in conjunction. So I think the purpose of this bill is to increase accessibility, you know, for members of the public who might have, you know, disabilities or other issues to allow people who are marginalized or haven't, you know, don't use, aren't as familiar with technology or something to be able to participate in public meetings. So this is slightly different. And I mean, I would recommend supporting the intent, but it might be burdensome because of the use of technology. If there's no, you know, guidance on what technology should be used for the board meeting. I'm going to click on it just to see if we can look at the language of this bill for discussion.
Yeah, I mean, I don't know that we need to take a position on this.
Okay.
But I think we can if you feel, if you want to make that recommendation and feel strongly about it.
I think, well, the major change is just instead of may, it shall, but yeah.
Because I think there was a similar bill before and we didn't take a position.
Okay.
I don't know, other commissioners can chime in. My memory might not be that great on that. Okay.
Okay. Okay, SB 2199 relating to public agency meetings, similar to Sunshine Law, it talks about executive session or closed meetings for purpose of providing training to new current board members. This is another one we might just want to watch. SB 2198 relating to a board packet. So another one we should monitor. And SB 2172 relating to responsibilities of individuals on a board or commission. Okay, so that was all the bills that we got before the 22nd when I was able to compile this list. We did get a substantial number after that, after I distributed that, but within the 48 hours. So we are compiling that. I will follow pretty much what Robin used to do and delineate it with a different color for next meetings. But I'll probably also include it in, include everything we discussed with the updates of staff recommendations and position of the commission for next meeting. So I'll try to get that to everybody by I think our meeting's on the next week, Wednesday, the 31st. So I'll get it to everyone by Monday
Okay,
or Friday. But
that sounds great.
okay.
That's a lot of work. So thank you, everybody who worked on that at the commission, because it's a lot. So thank you. And then this meeting is continued. We are just recessed, and then we will continue at 2 p.m. on Wednesday, the 31st.
Oh, sorry, sorry to interrupt you, Chair. But in our chats, we had a guest join our meeting, and then they had their hand up. I don't know.
I didn't see that.
Okay,
Fritz?
I'm Peter Fritz.
Yeah.
And I sometimes like to be guest instead of Fritz. But I was going to make a comment about one of the bills about interactive technology, which I think was 2116. And I think part of the reason is there's an accessibility element, but there's also an element of saying that the public on outer islands can participate in meetings. And the Board of Regents has now been saying we're holding an in-person meeting, everybody's there. Therefore, the rules under Chapter 92, 3.5 would say, have rules about what happens if there's a disruption or certain things about the conduct of the rules. They don't apply because all the directors are in the same room. And so that may be an element behind 2116. But I think the bigger element, it comes from a push from outer island people who want to be able to participate in a meeting. And since the state now is part of Office 365, everybody has access to Teams. So it really will be a question about whether or not the person wants to participate. And thank you for the opportunity to say something. And I think everybody's probably very tired right now. So I will basically sign off.
Good to hear from you, Peter. Thank you very much for those comments. We really appreciate it. We can, we're going to monitor it so we can look at it at the next meeting as well. So thank you for that. That's very helpful. Are there any announcements? I think that's the last item on my agenda.
Not an announcement, but a query. And I know that next week's meeting is expected to perhaps go longer, right? But all we're doing next week is continuing with the legislative packet, right?
Yes.
Okay.
Yes.
And the reason I ask is because I am gonna have to step off the meeting at 3:30 as I have another meeting. So I would be able to participate for an hour and a half, but not beyond that. And I'm hoping that we can maintain quorum without my presence.
Okay, I think we can, but I do think that, Connie, if there's anything that's particularly something that you want all of the commissioners to weigh in on, that you can order it accordingly.
Okay.
We get the benefit of Joan's comments, but we will have quorum if everybody else comes.
I was looking at my calendar. I have another board meeting at 4. So hopefully we can get our business done within 2 hours.
Okay, and so Connie will be sending out the briefing on the bills, so if folks can take a look at them and sort of have what your thoughts are. And of course, staff recommendations will be on that document, so you'll know where they stand, what they've thought about, and then it'll be an opportunity to ask questions, and then we can get through these bills. But okay, start of a new legislative session. Thank you very much. And we'll see everybody next week, Wednesday. Really appreciate it.